Our Executive Director, Susan Myers, is in the Salem office with staff from the investigative, training, and administrative sections of the commission. Our counsel from the Oregon Department of Justice, Sean Brady, also is in the Salem office. And for the record, my name is Dave Fiscum, and I currently serve as chair of the commission, and I am in the Salem office today. As for other commissioners, Vice Chair Shanoa Payne is online by way of Teams. Commissioner Jonathan Thompson is out of town and has been excused. Commissioner Dan Mason is online. Commissioner Rick Burke is online. Commissioner Alicia McCauley is online. Commissioner Ivan Resendez Gutierrez is online. Commissioner Ann Metler either is online or will be online shortly. Commissioner Peter Jancy is online. This attendance means today that we have a quorum, so we'll proceed today first with the first four items on our public session agenda. If I could ask just briefly one more thing from those commissioners online, if you could turn your camera on. I think some are on, a couple aren't. If you could turn your camera on briefly for a moment for us to go through a process of verifying that the true commissioners are online, that would be helpful. I see five of you online. I'm six. There's Mr. Mason. So thank you for that. We'll wait for Commissioner Metler at some point to join us. As chair, my comments this morning, and you can turn your cameras off if you prefer. Either way is fine with us. Thank you for doing that. As chair, my comments this morning relate to an item on the work session on our public session agenda, and I could make these comments in a moment, but I'll do so now. At least in Marion County, the issue of the serial public meeting law has tended to dominate various news headlines over the past few weeks. And to put a couple of points on it, the issue affects us as a commission just as it affects local governments. And the language in the law can be confusing for some of those affected by it, including on occasion, I would say, for me. To me, this makes it imperative in a few moments that we listen carefully to the status report provided by our executive director and staff and decide if there are additional actions that would be wise for us to take as a commission in view of this issue. For my part, this issue, serial public meetings, raises the need for legislation to at least consider fixing certain aspects of this public meetings law, parts of which are, for me at least, relatively new. But it may be difficult, if not impossible, to propose a bill in the short 2026 session next February, which means that a legislative fix will have to wait until 2027, the long session, and that reality will carry implications for our administration of this law, as well as for public policy in general. Internally, that inability to change things until 2027 means that all of us will have to live with sometimes longer agendas than we'd like. As you have seen by now, I hope one solid step our staff has taken in recent days is to prepare and post a detailed question answer document that I think does a good job of clarifying the situation for us. And it has had, I think, some effect of helping to assure that the issue we face from the at least immediate perspective is, to a certain degree, limited to Marion County, though there's always a possibility for that to expand. So we'll review that in just a few moments. Okay, that's enough from me. Our agenda also includes the possibility for comments to be made by other commissioners on topics not on our public session agenda today. A few months ago, I added this to our agenda so commissioners could make such comments. So I will ask this morning if there are any takers for other general comments you would like to make about ethics issues in Oregon. Any takers? Hearing and seeing none, and Mr. Jancy is smiling, so I appreciate that, Commissioner Jancy. Either you're laughing at me or smiling, one of the two, so I appreciate it. Okay, we'll now do one more thing on the public session agenda. We'll consider the minutes of the July 11, 2025 meeting. They've been distributed to all of you. Any comments on those minutes, corrections, deletions, clarifications? Hearing and seeing none, Vice Chair, please.
I move that the commission approve the minutes of the July 11th, 2025 meeting.
Thank you, colleagues. I presume there are no other questions. Hearing and seeing no hands, the administrator will call the roll, please, on the approval of the July 11th minutes.
Commissioner Mason.
Aye.
Commissioner McCulley.
Aye.
Commissioner Burke.
Aye.
Commissioner Payne.
I'm going to abstain because I was not present.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Has Commissioner Mettler joined?
No, she's not.
Thank you. Chair Fiscom.
Aye.
Motion passed 6-0 with 1 abstention.
Okay, thank you, colleagues. We'll now move to the public session agenda marked work session on serial communications. And that said, I will turn to our executive to begin this process of the work session. Please proceed.
Thank you, Chair Fiscom, commissioners. So I added this work session to the agenda to both give the commission an opportunity to review the frequently asked questions guidance that we issued a couple weeks ago, and to consider some of the nuances and the questions and the issues that have come up. For the most realistically, these have come up in trainings that our staff have done and in questions and advice, and they've come up in our discussions with the League of Oregon Cities. We did work with the League. That does not mean that everyone agrees on everything in here, but they did provide some helpful assistance in drafting this. But frequently asked questions, and so I'm going to briefly go through them and then discuss some of the issues. I know we did provide all of you with a letter from Chad Jacobs that highlights some of his concerns. We've received several other emails since. So let me go through the frequently asked questions and then we can discuss. So the first page of the handout goes through the essential definitions. You know, the primary one is the purpose and intent of the public meetings law, which is that the deliberations and decisions of governing bodies need to take place in public. That includes the information upon which decisions are made. And a lot of people, because the enforcement of public meetings law by us or any state agency is relatively new, a lot of people are acting as if the prohibition on deliberating in private is something new that we suddenly put in the law. It is not. It has been the law since the 1970s. And in fact, our DOJ counsel recently found a 1977 AG opinion that said if they're going, a governing body that wants to discuss or gather information for a decision, they need to do that in a public meeting. So the concept of the prohibited serial communications is that if a governing body is communicating among a quorum of their members for the purpose of deliberating or deciding on any matter within their jurisdiction, that is prohibited. So we look at the definition of deliberating. This was added to the Public Meetings Law in 2023. And it is discussions or communications that are part of the decision-making process. And in last year, the commission clarified what that means, what is included in the decision-making process. And it is from beginning to end, identifying the decision, gathering information, weighing and assessing, and then making a decision. The other matter is the definition of an intermediary, and it is a person used to facilitate communications among the members, sharing information one to another. And again, in terms of serial communications, that means the intermediary is facilitating communication among members for the purpose of deliberating or deciding. So if you move down into the actual questions, question number 1 really sets up, these are the 3 things we have to look at as a commission, as commission staff, to determine would there be prohibited serial communications. 1, do the communications involve a quorum? If it's less than a quorum, it's not a violation. 2, do they involve something within the governing body's jurisdiction? Something that the body can deliberate or decide on. And 3, did the quorum use serial communications for the purpose of deliberating or deciding on that matter? And use serial communications could include using an intermediary, a person, including one of their own, could include texts, emails, social media, handwritten notes. Are they using any of these things to communicate amongst a quorum in order to deliberate? So then we go through some of the basic questions that have arisen. Does the quorum have to be in the same communication at the same time? And the answer is no. There, in the handy case and in the guidance and in the law, there's nothing saying all of you have to be in the same thing. Serial communications does mean it can happen 1 by 1. It could happen 2 by 2. I give an example here about sort of board member A, board member B, and then they each go off and talk to board members C and D. If you have these communications, say you had to expand on that example, because a lot of the concerns raised both by Chad Jacobs and others is that we would be holding, they don't know that board member C is doing this or board member D is doing that. And I understand that. Say it was a 7-member board and 3 of those members meet up for lunch and start talking. That's allowed, right? Because less than a quorum. And then 3 of the other members are at the club and at the athletic club and they start talking again. But then you have a meeting of 1 member from each group. They meet with member number 7 and say, we talked about this. Oh yeah, so did we. You don't have a quorum in any of the groups, but what you do have is communication amongst the entire board at that point that is relating to deliberations on a matter before the council. So let me move through the rest, and I'm probably going to come back to this specific example and issue. So question 3, if the communication is not on a topic in the board's jurisdiction, not a violation. The prohibition only applies when they are communicating about topics within their governing body's jurisdiction. Question number 4, and this definitely relates to sort of the issues raised by the Salem City Council. I'm on a governing body. A constituent approaches me. Can I speak to them without risk of engaging in serial communications? What if they also approach other members? Basically, what they were coming to us and saying is, well, your rules mean we can never talk to constituents anymore. That is not what we were saying in our trainings. What we were saying is, don't try to communicate with your fellow. Don't use a constituent or a staff member or another governing body member to facilitate communications with your fellow board members. That does not mean that you can't speak with your constituents. So I attempted here to clarify. You can talk to your constituent about your body's business. That's allowed. And even if the constituent is going to each of the counselors to say, look, I really want a crossing light here, whatever it is, that's okay. What you cannot do is direct the constituent to be a go-between. Don't go and tell the constituent, I hear what you're saying and I'll consider your proposal, but I need to know what my other counselors think. Go talk to so-and-so and report back to me. That's when it would become a problem. They were also, moving to question 5, very concerned about, may I speak to a member of the media? We're hearing from media that counselors were telling them, we're not allowed to talk to you anymore. Again, there's nothing in the law saying you can't talk to the media or to your constituents or to anyone. What the law is saying is you can't use people to communicate, to facilitate communication amongst the board in order to deliberate. Question number 6. We're considering a matter. I want to know how everyone feels. Can I ask staff to find out and report back to me? No. The law sets forth 3 things that are not subject to the public meetings law. So if what's being talked about or considered is something purely factual or educational, and that conveys no deliberation on a matter that might come before the governing body, or something not related to anything that could be foreseen. For example, you're a school district in Clatsop County and your board wants to express a position or concern with, a forest management policy in Klamath County. The school district isn't in a position to make any decisions about Klamath County's forest district. Therefore, they could discuss those matters because they could not reasonably be foreseen to come before the school board. And then anything that's non-substantive, scheduling, who's going to be at the meeting, things like that. So if checking in with staff, then if you are checking in with me to say, I can attend, I can't attend, I can share that information with Chair Fiscom and the others. It is purely a non-substantive matter. Okay, so moving on to question 7, the city administrator question. I'm a city administrator. May I meet privately with members of the governing body to discuss matters subject to their decision or deliberation? And the answer is yes, with a codicil, and that's why I gave these 2 examples. So if the city administrator wants to ask each of the governing body members what their thoughts are on some proposal, like should the permit fee be adjusted. City administrator can collect that information from all 7 counselors and collect it. Counselors aren't talking to each other. The city administrator is collecting all of that information. And then can put an item on the agenda, assemble or compile the information, and present it to the council at a public meeting for the council to debate the issue. That would not violate the law. The second scenario is the city administrator contacts each counselor individually for their thoughts. And the mayor proposes, well, no, I think there should be a reduction. The administrator then conveys that proposal to each of the counselors. And another one makes a contrary proposal. You convey both options to all the other counselors. Well, in this case, the city administrator is acting as an intermediary so that the counselors, a quorum of the governing body, can deliberate the issues. So the first, gathering the information and presenting it in a public meeting would be okay, but gathering the information and sharing it amongst the quorum for the purpose to allow them to deliberate, that's what's prohibited. Question 8, may I attend town halls? This relates to the constituent matter, and this was again raised by the Salem City Council. They were afraid that they could never attend an association meeting. And it's the same answer as up above. You can attend these meetings, you can talk to your constituents. What you can't do is talk to each other if there's a quorum and it involves making decisions or deliberating. I do warn them, obviously, if you have a quorum of your governing body at a town hall or a neighborhood association meeting, you have sort of the other issue, which is you're going to need to notice that as a meeting of your governing body. Question 9, non-substantive matters. We've already discussed that. It's allowed. Question 10, can prohibited serial communications occur during a public meeting? So you have 9 commissioners here. A prohibited serial communication would occur if, like at last meeting, Chair Fiscom passed a note to me asking a question. That's allowed. That communication wasn't shared with all of you. But it's instead of passing it to me, he passed it to a quorum of the governing body. That would be, and it related to something, that would be a prohibited serial communication. Now, how could you fix that? Publicly announce what's on the note. You know, make it part of the discussion. So questions 11 and 12 are, what are the penalties? And they're the same penalties as any violation of the public meetings law. Question 11 is, how can you correct a prohibited serial communication? You didn't realize what you're doing. You only realize after the fact. You're like, oh, we might have violated this. I didn't realize a quorum was going to be involved. I didn't realize that we were going to end up talking about this, but we did. What do we do? There are steps you can take, obviously. The whole point of the public meetings law, going all the way back to that very first topic, the purpose and intent of public meetings law is to allow the public to be informed and aware of your deliberations. So if you found that your governing body did engage in serial communications, you can seek to correct it by presenting all of the information at a public meeting. So you had a series of texts and then the light bulb goes off and you're like, oops, at the next public meeting, say, okay, everyone, mea culpa, we made a mistake, but we're going to read you all of these texts, put them in the record. Or if it was a telephone conversation, here is what happened. I'm going to tell you what was discussed in this conversation so that everyone knows and it's in the record. That at least shows an effort to come into compliance. Now, I did add the second paragraph here, which is, that does not mean someone can't file a grievance and then submit a complaint to ODA. Always can. And if we receive that complaint, we have to open the case. We have no choice. But the attempt to bring the prohibited communications into the public sphere, let everyone know, and correct it is a consideration. It would be a consideration when we would write the preliminary review report, and could be a consideration that the commission could take into account in evaluating the case or determining the sanctions. The one thing I want to say about this document and this process, this is a living document. It is not the be all and end all. The document will be amended as the commission has more opportunities to consider these issues in the context of cases or opinions that may come before it. And there are some additional questions that likely need to be added. So I want to stress, because everyone is saying, you guys need to rescind this, or it's not a matter of rescinding it. There may be fine tuning that we do to examples or adding or deleting questions as time goes on and as the commission has more opportunity to consider the specific issues.
Director, thank you. I see one hand raised, but just a couple comments before I recognize that hand and throw it open to discussion, questions, answers, comments from all of you as colleagues. Two hands are now up. Just a couple quick comments. First of all, in some ways, I am the culprit for having this on our agenda today because, as some of you know, I live in Salem, and the issues that are embedded in this Q&A document have resonated in Salem for some weeks in several ways, in terms of the city council, in terms of the Salem Statesman Journal newspaper, in terms of the Salem Reporter, another online newspaper around town, and the issues about you can't talk to neighborhood associations, you can't talk to the media, you can't talk to constituents have risen here. They may not have risen statewide yet, and they still might rise statewide, but that's why this document is important as a placeholder, my word. It's a live document. It'll be updated as new information comes before us and as we understand more about this issue, some aspects of which are new to us. So I do want to throw it open to discussion. I have three hands raised, and that won't limit discussion. I want to start with Commissioner Burke, whose hand I saw first. Commissioner, please ask your question or make your comment.
Okay, I'll unmute there. Okay. Mr. Chair, as I'm listening to this excellent report from our executive director, I'm trying to think of how a public official, perhaps acting in bad faith, might try to circumvent this in such a way as they cannot be cited for a violation. And I'm wondering if this handles such things, I don't know if the term is correct, but like a Chinese wall. Like if I know a person, maybe an active constituent, who knows another active constituent who knows another commissioner, and I tell them something, without instructing them to do so, knowing full well that they will blab to the other person and it'll get back, to the second director. I'm just trying to find ways that they could get around the law in bad faith and if there are mechanisms or statutes or rules in place that would thwart some of those plans.
Director, please.
Okay. Well, thank you, Commissioner Burke. I generally try not to advise people how to get around the law.
Sure.
Probably not gonna get. What I will say is this kind of raises one of the arguments that gets made, which is that we should only hold people liable if they intended to violate the law. There is not an intent requirement here. And there isn't, as I think Chair Fisker may say, because we've had this discussion, there isn't an intent requirement in the ethics laws or in the lobby laws but what is important is that focus on the three questions. So in the communications with the constituent in your example, Commissioner Burke, we can't control what the constituents do. And I understand that, yes, we may know that this person's going to go talk to everyone, but the constituents have the right to talk to their governing body members. What we want to do is simply avoid then having them come back and tell me what the other counselors have to say.
Mm-hmm. Thank you.
Thank you, Commissioner. Commissioner Jancy, please. You're on mute for the moment,
Thank you.
but now you're off mute. Please proceed.
Thank you, Chair. Can you hear me okay?
Please, yes.
Okay. Well, I realize I'm relatively new to the commission. I may have missed previous conversations on this topic, so apologize if I'm catching up. And I certainly support the policy behind that the legislature's recognized behind transparency and deliberations. I do have a few questions and just trying to understand it. If I understand right, this guidance is the impetus for this is the amendments to the definition of meeting in 192.610. Is that where they've added the reference to serial electronic written communication and then the intermediary definition?
Director, please.
So in 2023, when House Bill 2805 was passed, and it gave us jurisdiction, the amendments that were made, yes, they'd added definitions to 610, the definition of what does it mean to convene a meeting. And that would include convening a meeting through an intermediary or by text or anything else. It added the definitions of deliberation. And then in 24, when we did the administrative rulemaking process, we added further clarifications and definitions, like what is included in a decision-making process. What constitutes serial electronic written communication and what would constitute an intermediary? You know, pointing out that an intermediary could be a different person, staff or someone else, but could also be a member of the governing body. So that's sort of the background.
Okay, thank you.
Please proceed, Commissioner. Please proceed.
Okay, thank you. Well, that may be partially the answer to a couple of my questions, but it just seems like in a couple places, the reference to serial communications is broader than the use in the statute of serial electronic written communications. For example, the guidance talking about how handwritten notes could be prohibited serial communications. That doesn't seem to be consistent with the use of the phrase in the statute, which is limited to serial electronic written communications. And similarly, the examples of convening a meeting under 610, we reference prohibited serial communications, including in-person communications, which I suppose could follow or fall under a quorum under the gathering clause. But I don't see another provision under 610 that would include one-to-one communications. So it seems like we're using serial communications maybe as a term of art or differently than the statute defines serial electronic written communications. Is that in the rules that were passed before I I joined? Okay.
Yes, so the statute defines the electronic communications, email, text, etc. What the prohibited use of office, what the rule says, let me find it. 199.050.0020 says is that a governing body shall not, outside of a meeting conducted in compliance with public meetings law, use a series of communications of any kind, directly or through intermediaries, for the purpose of deliberating or deciding. So basically, you cannot use serial electronic written communications. You cannot use an intermediary. You cannot use direct communications, telephone, meeting up at someone's house to communicate amongst a quorum for the purpose of deliberating.
And I'm sorry, that was 199.150.020?
050-0020.
0020.
And
Okay.
it specifies all the different ways: in-person, telephone, video, written, intermediaries, or any other means of conveying information.
Commissioner Jancy, any other follow-ups quickly before we move on? And please, if you have one, please proceed.
No, I'll take a look at that. It just strikes me as different than the plain language of the statute, but I won't waste the commission's time with me getting up to speed.
Thank you, and don't apologize. Just a quick preamble or postamble, whatever the word is. I was going to say that this is part of our administrative rules, and we are in the process of revising those, as we always do annually, at least, otherwise. And this rule will be revised along with all others. And so if there are contributions anybody wants to make to the revision of any rule, this included, the time to do so is now, so to speak. No urgency, but I think to the extent that, Commissioner, you have questions, I think you can forward those to our executive, and it will go into the rulemaking process, as well as revisions of the Q&A document you have before you. Two other hands have been raised. Commissioner Gutierrez first. Please ask your question, make your comment.
Thank you, Chair. I had a question about frequently asked question number 1. Don't we need an or somewhere in there? In the answer?
The answer to question number 1, you could say you might need an and. All 3 of those questions need to be answered for there to be a prohibited serial communication.
Right. Then
Quorum, jurisdiction, and deliberation.
Yeah, then I would include I would suggest that we include an and in the answer to FAQ 1.
Thank you, Commissioner. Any further comments? Please proceed if you do.
Yes, one more. I think this is great. And I appreciate that the bottom of the document says that we may supplement with additional questions and answers. My suggestion is and that it says, please contact our office with questions. I'm a fan of FAQs. At the same time, they come with their own issues. Like, people think that this is an all-encompassing FAQ of every serious question. So I looked at the document and also on the website, and my suggestion would be to add some language that says, to be clear, this is not the most important questions or the most serious questions. Like, these are just a sample of questions that are frequently asked. And I know that's implied in frequently asked questions, but I can't tell you how many times I've done an FAQ for a legal seminar, and then I get, well, you missed this other question that is actually the more important one. So that would be my suggestion or if I had been warned in your FAQ, I wouldn't have done it. So just a suggestion for that. Thank you.
Commissioner, and I will add, the other, and this may be inherent in the document, but I think the executive is talking about this the Q&A document is not carved in stone. It's a nimble document, and it will be added to and or subtracted from along the way as new information comes up. And colleagues, one of the issues that's going to face all of us in the next months is this issue that we're talking about today, which is why we're spending time on it. Because it's going to be, whether it dominates your agendas or not, it's going to be a clear aspect of your agendas going forward. Vice Chair, please.
Thank you, Chair. So I have a couple of concerns regarding sort of how we would hold individuals liable, or I guess that's not the right word, how we would possibly find violations of the public meetings law under these serial communications. And the first is in looking at definitions of serial communications, I'm not seeing any sort of limitations on timelines. And so like looking at the example in the FAQ, there is on page 2, and this was one of the concerns I think raised by Mr. Jacobs, was, one person can send a communication to one individual, and down the line, another person sends a communication to another individual, and then down the line, another person sends a communication to another individual, and at some point it becomes a quorum. And I guess I'm sort of wondering if there's any limitation on that time and on that time frame whatsoever. So could that later communication happen 1 year later, 2 years later, 10 years later, and that's a serial communication? So I'm sort of wondering, is there any limitation on that time frame such that it's a serial communication, or is it cut off at any point? And I know that our time frame is 4 years, so maybe it's 4 years, but or our jurisdiction is 4 years, but I guess I'm just sort of concerned at how far apart do these communications have to be, or close in time do they have to be serial? That's sort of my first question. And my second question has to do with the fact that there is no intent or knowledge requirement under this. And so when does a violation take place, and who has violated the public meetings law? Because it seems that the first person who has engaged in that serial communication with one other person when no quorum has existed hasn't violated any public meetings law. The second person who has communicated, if there's 4 people and that doesn't constitute a quorum, also hasn't violated any public meetings law. It isn't until a quorum actually exists that the public meetings laws have been violated. But are we going back in time then, once that quorum takes place, and saying that everyone involved has violated public meetings law? I have a problem with that. To me, holding the first people, saying that they have violated public meetings law when they maybe were very careful not to engage in communications that involved a quorum, but then being saying they violated public meetings laws because other people down the line shared their communications with other people. I guess I think we need to think very critically about when a violation takes place and who actually has violated public meetings laws when we have these serial communications. And I think we need to think critically about those issues as a commission, because I understand there's no knowledge or intent requirement, but I think, if people are being very careful about not violating the laws and then somebody else is the issue, I think we need to be very careful about that. So those are sort of my two issues or questions.
Becky, do you have two questions, both for you, unless you want your staff to answer them?
No. So, on question number 1 about limitations on timeline. That is up to the commission. If the commission wants to propose that we limit, because I do understand that concern. Are we talking 1 week? Are we talking 1 month? Are we talking 1 year? The committee, that could be part of a future rulemaking. One of the issues is where you have a governing body like yourselves that now meets monthly, or a city council that might meet weekly, things move in a pretty quick period. And so you would expect the communications to be within a relatively reasonable time frame. But there are governing bodies out there that only meet once a year. Or there are actually, I think, there might be some governing bodies that only meet once every 4. I mean, there's this wide variety of how governing bodies work in terms of their time limits for communication. So, but certainly I think that is a question that the commission could answer either in the context of a case or an opinion or in some future rulemaking. The second question is also going to be a matter up to the commission, and likely fairly soon, because as I've pointed out, it's now an investigation, so it's public record, but the commission has its very first serial communication case that has come before. And realistically, while everyone wants to talk about serial communications as being so important here, realistically, the commission is not likely to get a lot of serial communications cases. And that's because of the grievance process. Someone would have to know that all these communications took place, file a grievance within 30 days of the communications, and go through the complaint process. Most of the time, members of the public or other people are not going to know in time to file the grievance. But what is going to be coming before the commission in the city of Salem case that's in investigation is an opportunity for the city to make some decisions on the questions you raise. Meaning, are we only going to hold the person who initiates the communication legally responsible for it? Are we going to hold everyone who participates? Does it matter what the extent of that participation is? Those are some questions that the commission will have an opportunity to answer.
The city of Salem case exists, as you may recall, nine individual members thereof. And so this issue that you're raising, your second question, Vice Chair, as executive says, will be before us all in September. And there may be some work. Well, yeah. The goal is September. There may be some analysis we'll have to do before those documents are produced for September. But very good questions. Vice Chair, any follow-up, please? If there are, if you have follow-up, proceed.
Well, I mean, I think we have an opportunity here to give people notice about what serial communications mean and what a violation of public laws meetings mean under this. And, if we're going to think critically about this, it might be an opportunity to add something like that to the FAQ.
Yeah.
So I mean, if we don't even know, how are they supposed to know? It seems like maybe a missed opportunity to explain. I don't know. I guess I'm struggling with understanding at what point the violation occurs and who has violated the public meetings law. And if we don't understand, then how are we supposed to expect public officials to know when the violation has occurred and whether they violated public meetings laws, and how to instruct them not to? I mean, I guess if we're saying you are at risk of violating the public meetings laws anytime you engage in any communication about a substantive matter with anyone on your public body outside of a public meetings law, I think that's not what the law prohibits, and seems a little bit unfair because the law only prohibits communications if they're amongst a quorum. But what we're saying is you better be careful, because any communication that you engage in, well, you could possibly be violating public meetings laws because somebody else may share your communication, and down the line it may become a quorum, and ergo you may be violating public meetings laws. And to me, I mean, as a lawyer, it seems like a tough pill to swallow to say you actually may be violating public meetings laws, even though at the time your conduct wasn't a violation of public meetings laws. I just think that's it's really tough to, I think, for this body to adequately advise public officials that they're really not supposed to be doing something which is actually not a violation of public meetings laws.
Executive, please respond, but I think what this indicates is we need to take a new look at our FAQ with regard to a couple of the examples that the vice chair and others have commented on, to which end, I'm not trying to describe the end, I'm trying to describe the process we need to go through, because I think these questions are very good ones.
Absolutely. And I absolutely see that concern. I think when we are we try to convey sort of best practice. Best practice is simply don't talk to each other or engage in deliberations on matters. Save them for a public meeting. But I understand the idea of prohibited serial communications can seem like a very slippery slope, you know, that the conversations between one or two people suddenly balloon. And at what point? That's a decision for the commission to make. If you want to say it's only board member number 5 who creates the quorum that we're going to hold responsible. Or if you want to say it is the board member who reached out and called all of the other board members that we want to hold responsible. Or if you want to say it is the 5 board members who then started really talking about it, one after the other, or even together, that we want to hold responsible.
Okay, clearly on this issue, work to be done. Before turning to Commissioner Jancy, just one quick comment for the record. I believe Commissioner Medler joined some minutes ago. So Commissioner Medler, glad you're here. Welcome. Just for the record, wanted to make that comment. And Vice Chair first, any follow-up comments? And thank you for your questions. Appreciate it. Commissioner Jancy, please.
Yeah, I just wanted to clarify, when we say there's no intent requirement, are we saying there's no intent to convene? There doesn't have to be an intent to convene a meeting. And if so, what's that based in? What's the authority for that?
Executive or legal counsel, either one. This is the intent issue that I've raised with you privately, but I'm happy for discussion.
So, hold on a second, let me pull up the definition of convening. So it's 192.610. Convening is defined as gathering using electronic communications, using an intermediary or using an intermediary to communicate among participants. So the idea that intent I mean, the intent to use the communications method, intermediary, electronic, handwritten notes, whatever, I guess, you know, when Chair Fiscom writes the note and passes it to someone, that, if you want to consider that being intent, that's the use of the note. I think the maybe slightly getting more to intent is for the purpose of deliberating. So, and
My question is-
attorney's going to disagree with me.
No.
do we as a commission ever get to the point of, quote, establishing intent, unquote? Answer that question or make your comment, or both.
So there's no word that this isn't criminal law. There's no word of intent. The words that are used are for the purpose of deliberating and things of that nature. So those are the words of the statute. 192-620 has an overall policy of the legislature has determined since 1970s, we want a sunshine open government, and we want information, we want decisions, we want discussions and deliberations to be done in a public manner. Also, 192-630 sub 2 then prohibits public bodies from engaging in deliberations for the purpose, for the purpose of deciding or deliberating in private. And so there's that component as well. And the administrative rules are holistic in looking at both what is allowed and trying to clarify what is also prohibited to do in private. And so that's kind of the global look at, I guess, what the administrative rules are trying to provide. And this, I'll just stop there. I can.
Commissioner Jancy, if you have any follow-up, please proceed.
Well, I appreciate that response. It just seems to me that the statute is defining meeting and it's talking about convening a government body, which it sounds like is interpreted as convening a quorum. So if you act to convene, it seems like it necessarily includes some intention to gather a quorum. But I appreciate the response. I'll study the issue.
Yeah, just to real quick. So for instance, in order to convene, you have to do public meeting notices and everything else, right? And so that's the intent that they're doing when they post that, but they don't always do that. And so sometimes they will hold a meeting without following the actual law, and so there's no kind of intent element in that. So the intent is when you intend to hold a meeting, you're supposed to post a notice, you're supposed to follow the law. And so sometimes that doesn't occur every time and violate that law. So.
Thank you. Legal counsel, helpful to me. Colleagues, any other comments or questions from anybody? This is not a subject which we've completed today. It's only a subject we've spent some time thinking about, and your questions have been very helpful. Our executive and staff have taken notes, and this is a work in progress. Executive.
And I would just say I will talk about it further in my executive director report. But yes, this isn't the end. This is part of the discussion. The commission will be considering these issues both in the context of the case that will come before you, hopefully in September. But I would also encourage you to send me, as we consider what any amendments or changes to the FAQs or additional questions, or if there is a topic that you would like the commission to either do in its rulemaking or consider a change to the FAQ or to do an opinion on, send me that so that I can do that. I am also continuing to discuss these issues with the stakeholders, with LOC, with Rep. Sosa at the legislature, with Chad Jacobs, et cetera. So we are trying to get everyone's input to come up with some additional clarity on the issues.
further, but besides the law, which exists, ORS, et cetera, whatever it is, take a look at Division 50 of our OAR 199 and take a look at the language therein, as I have done, not to a conclusion yet, but that administrative rule is in the process of being reworked, not perhaps in total, but in part. So take a look at that, and if you have suggestions, forward those on as well. Colleagues, thank you for your consideration in the last hour of this issue. It's an important one for all kinds of reasons, and your questions illustrate that. So thank you for engaging. Any comments for the good of the order before we proceed? Hearing and seeing none, thank you, Executive. Any other comments for us? Okay. Okay, colleagues, we will now proceed. Just a second till I get my papers in front of me, which is important because I lost my notes. Here it is. Thank you. Okay, we will now move into the executive session for this day. Some comments first. First, I presume this is not necessary, but the question, does anyone need to declare a potential or actual conflict of interest pertaining to a matter on the exec session agenda? If so, now is the time to make such a declaration during the public session. Having heard of none to this point, I will assume there are none.
Yes, there is.
yes,
Sorry. This is
Mr.
the,
Gutierrez, please.
thank you, Chair. Classic form, I have just a couple of conflicts, potential conflicts I need to declare on the executive session agenda. They relate to number 11, 25-318 EAM Vance Lump, and number 14, possible own motion preliminary review, Juan Carlos
Don't say it out
Molleda.
loud. Wait,
Oh, sorry.
it's okay to mention that, but don't mention the name because it is confidential.
Okay.
We're still in
Sorry.
public.
no
Possible. Yeah,
Okay.
possible own motion. And so number 14, and the reason for the declaration is that my firm represents those two entities or individuals. And yes.
Thank you, Commissioner. Any other declarations in the public session for the exec session? Okay, a second comment, our staff is maintaining a list of representatives from the media who have told us they will attend the executive session under provisions of state law in Oregon. Are there any questions about that list before we move into exec session?
No, Chair.
Thank you very much. Appreciate that. Okay, let's make the move, but one brief reminder again before I read our authority. I say this to myself as well as the rest of you. We need to limit side conversations because our technology is sensitive enough that it can pick up those conversations, especially as we are involved in the technological process of admitting persons into the executive session or removing them. So such comments, even in a low voice, can become part of the official record. Before the on-site and virtual doors are closed, I'll read for the record the specific statutory authority that enables us to proceed in this way. The Oregon Government Ethics Commission will now meet in executive session to consider preliminary reviews, to consider whether to open a case on the commission's own motion regarding potential ethics violations, and to obtain confidential attorney-client privileged advice. Representatives of the news media and designated staff shall be allowed to attend the executive sessions. When we enter executive session, all other members of the audience will be asked to leave the room. Everyone currently joining the meeting online and over the phone, other than representatives of the news media, will be removed from the meeting. If your case is being heard in executive session, you will need to rejoin the meeting where you will be held in the virtual waiting room until the commission is ready to hear your case. Our staff will text you on the number you provided them to let you know when we are about to hear your case. The first executive session is being held under ORS 192.660 sub 2 sub F and ORS 244.260 sub 4 and ORS 192.685 sub 1 to conduct preliminary reviews of ethics and public meetings law complaints. Representatives of the news media are specifically directed that after the commission has made its final determinations and adjourned the executive session, they may report on their preliminary review cases items 1 through 13 on the executive session agenda, including the commission's deliberations and its final determinations. ORS 244.260 sub 4 sub D sub C authorizes the commission to deliberate and make its final determinations on preliminary reviews in executive session. Following the conclusion of the meeting, the commission will publicly disclose and post the audio and video recordings of the preliminary review executive session. The second executive session, item 14 on the executive session agenda, is being held under ORS 192.660 sub 2 sub F and ORS 244.260 sub 2 sub D to consider whether to open a case on the commission's own motion regarding potential ethics law violations. Representatives of the news media are specifically directed that they may not report on or otherwise disclose any of the deliberations of anything said during the own motion proceeding, except to state the general subject of the executive session as previously announced. Own motion proceedings are confidential under ORS 244.260 sub 2 and remain so even after the executive session is adjourned. The third executive session, item 15 on the executive session agenda, is being held under ORS 192.660 sub 2 sub F to obtain confidential attorney-client privileged advice. No decisions will be made in the executive session. Representatives of the news media are specifically directed that they may not report on or otherwise disclose any of the deliberations or anything said during this separate executive session. The audio and video recordings of the second and third executive sessions will not be posted or publicly disclosed. Once both executive sessions are concluded, all of them, we will return to open session and welcome the audience back into the room. That concludes the reading of our authority to proceed as such. So I will now instruct the staff to close the on-site and virtual lobbies, and we will proceed on the executive session agenda as indicated in the document you have before you. Executive, is that adequate? Legal